Welcome back, everyone. We're now ready to start with the second panel for today, which discusses cooperation with the relevant instruments, frameworks, and bodies under the BBNJ Agreement. I welcome on stage our moderator and panelists. The session will be moderated by Professor Zhen, Associate Professor at the World Maritime University.
Good morning. Thank you very much, moderator. Good morning for joining us. We have had very interesting discussions yesterday and today. And this theme is focused on cooperation with IFBs, which has come up again and again over the discussions, no less in the first panel by Professor Joanna. And this panel will look closer to this topic and what we can offer as opportunities moving forward for implementation. So as the moderator said, I'm with the World Maritime University, Sasakawa Global Ocean Institute. Before that, I was actually part of the home team at CIL. For some of the early victims of this process might remember, in February 2016, CIL organized a big conference with the delegates to prepare for the preparatory committee. I think David, you know, were part of the group at the time. So maybe it's no coincidence CIL is organizing another major conference ahead of the preparatory commission. And so as the moderator, I was asked to introduce our panelists briefly. So sitting next to me is Professor David Freestone, who has been praised as bringing in the concept of environment to the World Bank, and currently sitting as the Executive Secretary for the SAC-SOC Commission. Next to him is Mr. Hane Lafba, who is a senior policy legal advisor at the Netherlands Ministry of Foreign Affairs. Sitting next to him is Ms. Dr. Yuna Lyons, who is a senior global fellow with the CIL and the chair for a Committee for the Protection of the Sea. Next to her is Ms. Nicola Clark, is the senior officer at the Pew Trust, and she leads their work relating to the BBNJ. Our last panelist is Victoria Vaga-Lesses. Sorry, excuse my pronunciation. She's a senior fishery officer at FAO. She shared yesterday, she's also taking care of the project with Jeff to establish the Common Ocean Program to promote the ratification and implementation of the BBNJ Agreement. So as our title suggested, we'll look closer to the requirement of not undermining. This provision has been specifically written in Article 5.2. If I may start the panel with the interpretation of how we should understand this concept, may I first invite Professor David Freestone to give us a little bit more on the practical and operational level, how we should understand this concept, and whether the requirement to promote coherence, coordination, plays obligation for the COP, the BBNJ. David, please.
Okay, thank you very much, Zhen. And let me start by joining others in thanking the Ministry of Foreign Affairs, CIL and Mara for their hospitality, and also congratulate them on this really interesting and rewarding symposium. So, I think when I first saw this question, I thought, well, what about heinous sin have I committed in previous life that I should be the first to talk about not undermining on the panel? Because it's a phrase that kind of sends a shockwave through the system. And so I decided to answer it not as a legal academic, because I'm a kind of recovering law professor, but as the manager of the SAC-SOC Commission. So it makes it slightly easier, I hope, more practical, more useful as we look forward. And certainly, I'm editing with Joanna Mossop the commentary on the treaty, and we've got a lot of people who've written extremely wise things about it, so no need to go there. But just perhaps to remember that in the early days, and in 2016, at the conference that Zhen just mentioned, I actually was, and others were talking about maybe this is an opportunity for us to rethink the whole architecture of ocean governance and maybe set up a new institution that would actually have holistic oversight of the whole ocean regime. In fact, I seem to remember the Africa group actually put forward the proposal that should be the seabed authority, that should become a wider sea authority. So that term, not undermine existing organizations, was a pretty firm red line that was put down by a large number of states, mostly in support of the fishing organizations, that this is not going to happen. So it's been with us for some time. And I think that in the final text, it's very well balanced by the obligation of coherence and coordination. So it's a two-sided. Shouldn't call it a sword, but it's a tool with both ends. And the way that the treaty is constructed, I think that we can see the balance that the negotiators were looking for, because there's an obligation of the parties, and let me just, I think it was, I can't remember who it was yesterday, was it Ina who made the point that we're not, when we talk about the conference of the parties, it's only the parties. It's not, it doesn't have an entity of its own. I mean, it exists as an entity, but it's not a legal entity. So the obligations that are taken on by the parties to this treaty, to this agreement, will be those of the parties. And those parties have an obligation both through the BBNJ agreement to exercise coherence and coordination, but also as members of other organizations. So it's again a two-sided issue. There are obligations, remember, on the COP to actually reach out to other organizations for cooperation. So it's quite a finely balanced issue. It's clear that the BBNJ COP doesn't have overarching powers. It can't supersede any other organization, but it is an obligation of cooperation. And obviously in the first instance, I mustn't talk too long, but in the first instance, I think the COP will be fairly cautious about where they go with this. I'm actually cautiously optimistic myself, as working with the Sargasso Sea project. We're pretty cautious that cautiously optimistic in the sense that we've already experienced quite a lot of good vibes from the secretariats of the other bodies. And we, for example, just signed, we have an MOU with ICAT, which I think was the first organization of our kind to actually sign an MOU with ICAT. We have a long-standing MOU with the Northwest Atlantic Fisheries organizations. We have one with ISA. We've got good cooperation with IMO. So the secretariats, at least, have got the message. So I'm cautiously optimistic that we can move forward with that.
Thanks, David, for setting the scene and introducing the Sargasso Sea. And moving on to Renee, if you were part of the working groups for the EIA, actually chairing that body. So taking a forward-looking perspective, how do you see that the BBNJ COP might promote such cooperation and the obligation of not undermining with the existing bodies?
Thank you, Zhen, and thank you for moderating this panel. And I'd like to join David as well in thanking the organizers for their hospitality and organizing this wonderful meeting. It's good to be back among an old crowd that I have known for so many years. Now turning to Article 29, which is the article addressing the relationship between the BBNJ Agreement and the IFBs. I would have to say, and to start with, it takes two to tango. And that brings me to sharing with you a rather sobering experience I had last year when I participated in the Antarctic Treaty Consultative Meeting in Kochi, India in May. I was there not as an ordinary delegate. I had a different role, so I was observing the debate from a distance. What happened there that several parties had introduced a resolution, and that resolution proposed to recognize and welcome the adoption of the BBNJ Agreement. However, there was disagreement with that proposal, and that disagreement with the proposal was to recognize, and I quote, to recognize the significance of the BBNJ Agreement as a global milestone consistent with the role of the Antarctic Treaty System in Antarctica. And this is a quote from the final report, and so is the next one. And I quote, "The provisions of UNCLOS were undermined, and that norms of the BBNJ Agreement would allow for intrusion in the mandate and competence of relevant sectoral and regional organizations." So no consensus, and therefore no resolution. And let me now then turn away from that sobering experience and look forward and look at what Article 29, in particular paragraphs 1 to 3, request to be done. First, I think I would like to focus on the word parties in paragraph 1. Parties shall promote. And the question that you would have to ask yourself, what does this mean? Parties shall promote. It's not each party, because it doesn't say each party, so it's more than one party. It cannot be all the parties, because not all the parties to the BBNJ Agreement will be a party to the particular IFB. But still, I would consider this to be a collective obligation, and an obligation that requires the parties to the BBNJ Agreement, when they are also participating in an IFB, to coordinate. And one of the tasks for you is to ensure that that happens. So I would say that the COP should encourage parties to the BBNJ Agreement, when they get together in the framework of an IFB, to coordinate on sharing with that IFB the work of the BBNJ Agreement. Then turning to paragraph 2, paragraph 2 speaks of mechanisms of collaboration. So you have to start wondering, what does that mean? What I think it means, or could mean, is mechanisms to exchange information. I think it will be important that the Secretariat of the BBNJ Agreement and the Secretariat of the IFBs will have access to each other's website, and will have the opportunity to upload materials in order to share information. It will also be important to get it on the agenda. So yes, it will be on the agenda of the COP, how we are going to collaborate, and the STB in particular, because this provision is addressed to the STB, how we're going to collaborate with IFBs. But getting it on the agenda of the IFBs is something else, and will require you to do some outreach and to do some convincing that time is devoted in the IFBs for this interaction between the BBNJ Agreement and the IFBs concerned. Hopefully, we can go a step further, and a second modality would be that we exchange views, not just information, but also views. Now here it already becomes a bit more sensitive, depends on the mandate. But again, it would require the item to be on the agenda. From there, we can go a step further and say, well, there should be consultations between the scientists, the STB on the one side and the scientists of the IFBs on the other. This will pose some institutional challenges that you should overcome in terms of mandate and format. And finally, and pretty critically, it is important that the BBNJ secretariats will seek observer status in the IFBs, and vice versa. I don't think that will be a problem looking at the relevant provision of the BBNJ Agreement. we should be flexible about that. But obtaining observer status in each and all of the IFBs may be more difficult. And in particular, the practical challenges that you will face there, because that's going to cost a lot of money, and you will have to have people to be able to go to all the meetings of all the IFBs. Then you may only hope that the IFBs will come to you. And I can tell you, going back to my example of the Antarctic Treaty Consultative meeting, that meeting is not going to provide a budget line for the Secretariat to come to meetings of the BBNJ. Not going to happen. Now, the ATCM is notoriously reluctant in engaging with international organizations. I remember all the letters from the DOLOS Secretariat that negotiations on BBNJ were ongoing, and then those letters were circulated and noted, but nothing was done with them. So I hope the other IFBs will be more welcoming, and perhaps Victoria would like to tango.
Thanks, Ernie. Before I turn to Victoria, I wanted to reach out to Una. If we compare those different sectors, as we said, that this requirement of not undermine has been throughout the whole process. If we take the example of ABMT and EIAs, we actually observe some differences in the concept and terminology they used. So I would like to ask you how to differentiate the COP's approach to ABMT and EIA in terms of the relationship with other IFBs, and the expected difference in interpreting the concept of compatibility used in ABMT and the equivalence used in EIAs.
Can you? Yeah, that's right. Thank you, Zhen. And thank you for the questions. And thank you to Singapore MFA and CIL for inviting me to join this important symposium. I'm honored and very happy to be among you. So yes, the not undermine concept, I see it as having different characteristics or present itself in different ways, in different parts of the BBNJ agreement. However, those differences are also linked to the particularities of each part and the very different beast that the treatment of the EIA and the ABMTs have been. And it seems to, the approach I'm going to be taking is also a cautiously optimistic one, following on the path of David Freestone, choosing to see that there is a consistent way to look at this notion of, or this rule of not undermine. There can be a coherent approach throughout that is also coherent with the general ideas of international law functioning as a coherent whole towards the protection of the marine environment as provided in part 12 of UNCLOS and as it has been subsequently developed. So it won't resolve everything, but at least it's one way we can limit areas of disagreements to perhaps a few situations. So to elaborate on this, I would like to consider with you first the ABMT. There was okay, so we'll start with the top of the first part. I meant to click it so that you wouldn't have it all at once, but it didn't quite work out the way it was planned. So the first part of the slides as the ABMT, you see the ABMT process, which is very much a COP-driven process. So it's the conference of the party that will that has the say and will make the decision. What you see there is that there's a number of entry points. It's a detailed and sophisticated mechanism which is developed in the BBNJ agreement. And there's several entry points since the very beginning for consultations with IFBs. So at the end, and it will be up to the COP to decide, but with this obligation to not undermine and to respect the mandate of other IFBs. So if I move now to the EIA in the second part, it's a very different approach because it is a state-driven approach. So the state is in charge of the process and is in charge of the final decision. And certainly the BBNJ agreement is providing us with a very detailed process that has to be followed, and with transparency and many steps that are very usefully codifying international law on that topic. However, it remains there again, a state-driven process. And what you can, and it's at the end, though, this obligation or the way in which the states will follow that process, obviously has to respect the rules, unless there is an IFB that would have already done the work, or there would be an equivalent approach that has been, a report that has been done. All of the documents are published to the clearinghouse mechanism. What we see with these two different processes is how different they are, and just by nature, and that we have still a lot of work ahead. And I think it was useful to hear the co-chairs of the PrepCom setting the path for what will be needed. But what we can see here is that whether it's in the development of what not undermine, the way not undermine will be applied for ABMTs. The text of the BBNJ agreement refers to guidelines that will need developing. In the same way, for the EIAs, we are also in great need of guidance to see how states should be should apply this. So I would like to the second point I would like to make very briefly is through sharing a study that we did with at CIL some years ago, when we were doing our homework for the ASEAN, trying to understand what it meant for ASEAN countries to negotiate the BBNJ agreement, what was at stake, what mattered to the region. So we mapped, and this is this very overwhelming map that you have in front of you, and yes, I will not look at every bit on it. The whole point is that what we found is an awful lot of processes, and certainly a very long a very large number, and more than we thought actually, number of IFBs that had a mandate on different aspects. So the bottom, and I think that's the main point I wanted to get to, is that there's a lot of work to be done, but it's really important to acknowledge, and not do more than acknowledge, get to better understand the many processes that are already working in parallel to each other, in order to appreciate and determine how to adequately do justice to this, not undermine, do justice to the work that they're doing, so that the BBNJ agreement can fully develop its potential and work in complementarity with the existing processes to fill the gaps that are needed. So I will stop here. Thank you.
Thanks, Yuna, for sharing that comprehensive landscape. Follow up on Yuna's comment on, and also within the concept of ABMTs. Nicola, could you give us, what do you consider would be the opportunities for the BBNJ COP and bodies to work with IFBs in this framework? Thank you.
Thanks very much for the question. And I'll also echo my panelists. Thanks to the organizers for this incredible event. I'm reminded of a comment that one of the delegates made during the BBNJ negotiations, which is, it's all very, very smooth on the surface, but I'm sure there's an awful lot of pedaling that was going on underneath the surface of the waters to pull off such an incredible event. So thank you to all of the organizers for the work for that. Maybe just a bit of an observation on this not undermining, since we have an opportunity to talk about everyone's favorite topic on the BBNJ Agreement. So it was observed, I think, by several delegates to the negotiations that not undermining was the negative framing of this possible relationship between BBNJ and IFBs, and that collaboration and coordination and cooperation was the positive framing. But I would argue that collaboration and consultation is not just the positive framing of this possible relationship between BBNJ and IFBs, but it is, I believe, the solution, the answer to how we not undermine. So turning to the specific ABMT chapter, I recall at one point when I was in an event where Rena was talking about this symposium, and she said she wanted it to be very practical. So I tried to think quite practically about the different sort of entry points within the ABMT chapter that provide an opportunity for IFBs to not be undermined. Or put another way, an opportunity for IFBs to be consulted with, collaborated, and coordinated with when it comes to the establishment of area-based management tools. So the first, I'll focus specifically on the ABMT establishment process. And you'll note I've put the sort of references to the BBNJ treaty text in bold there for those of you who have your treaty text with you handy dandy in case you want to follow along. So I think one that I would observe is within the pre-proposal consultation process. So I think everybody focuses quite a lot on the formal consultation process that happens after the ABMT is submitted. But just a reminder that actually there's meant to be consultation with IFBs in the process of developing the ABMT proposal. So I would argue that that is actually bite one at the apple that IFBs have in sort of shaping the outcome of these potential ABMT proposals. So then sort of moving on to the next opportunity that I see for cooperation and coordination, which is part of the formal consultation. So after a party or a group of parties have submitted the ABMT proposal, that's of course when the formal coordination consultation, process starts. This, I argue, is the second bite at the apple that an IFB would have to provide comments on the ABMT that's being proposed. And just building on, I think Joanna in her presentation yesterday raised a lot of really great questions thinking about compatible measures, thinking about 22(1)(b, and what might compatible measures be. Theoretically, you could see a possibility where IFBs themselves might identify compatible measures that the BBNJ could adopt as part of that 22(1)(b power that the COP has. So next opportunity for collaboration would be when the IFBs may actually receive recommendations from the BBNJ COP with regard to measures that they might adopt. So for example, and I think, when we talk about IFBs, people often focus on RFMOs, rightly so. I think that's going to be one of the really tricky ones. But in sort of reflecting on some of the other IFBs and other tools they use, thinking about the IMO and particularly sensitive sea areas, in all but one instance that a PSSA has been established, it's done so after a marine protected area. So the marine protected area came first, and then the IMO established a PSSA afterwards, sort of taking its lead from that other process. So I think we could see that happen again in this instance, where you have a BBNJ ABMT that's adopted, and part of that would be a recommended measure, perhaps to the IMO for the IMO's consideration. And then finally, well, maybe penultimately on this ABMT process, you have some IFBs members. So you have states, of course. States are going to be common throughout all of these different tables that they sit at. But you have some states that may have an obligation by being both a BBNJ and an IFB member to advance certain proposals that are recommended by BBNJ to IFBs or to RFMOs specifically. And then a final potential opportunity of interaction, of cooperation, coordination, is a bit more of a theoretical one. So many in this room will remember the pretty intense negotiations for whether or not the BBNJ COP should be able to recognize ABMTs that other bodies establish. Now, at the end of the day, there was disagreement. And so what we ended up in the text is a hook for theoretically maybe one day, if the future BBNJ COP decides, they could establish some mechanism for recognition. And that, again, would be another process for this sort of coordination between these different bodies and coherence between different bodies. And I know I want to wrap up on time, so maybe just finally some observations for ongoing opportunities for collaboration and coordination. So that would be through the regular formal consultation process. We heard from Renee earlier about this coordination and cooperation mechanisms within EIAs. Those also exist for ABMTs. So that provides an opportunity. And then a final opportunity that's sort of ongoing is for IFBs have an invitation, but not an obligation, to share reports with the BBNJ COP on measures that they have adopted to achieve the BBNJ objectives. So again, another opportunity that we see for coherence, coordination, and cooperation between these different bodies. Thanks.
Thanks, Nicola. Turning to our last speaker for the rounds, if you can help us to probably summarize from a general perspective, what are the major challenges and opportunities for this provision? Victoria, please.
Thank you very much. And I'm very glad to be here today with you. It's a very interesting panel. It's also nice to be the last speaker because it gives me an opportunity to reflect on also what the other panel members said. And I was even called explicitly to reply some of the comments or mentions that Renee was saying. So I am bringing here the perspective of potentially relevant IFBs. I am representing FAO, which is working very closely with the regional fisheries bodies. It's a global policymaking body, very active in fisheries governance and also in the management of the areas beyond national jurisdiction. I would like to start by saying that we see the cooperation and collaboration foreseen by the BBNJ Agreement as a huge opportunity to move towards a more integrated governance of the oceans. And it's also a strong expression of the will of the states who signed this agreement or who negotiated this agreement that we should move towards into this direction. So setting our minds into this positive mindset. And I liked very much the comment yesterday about inclusive governance. I also advocate for that, and I start my statement talking about inclusive governance because I believe that a consistent and sufficient representation of the IFBs will allow the bodies and mechanisms of the BBNJ Agreement to draw on their expertise and knowledge. So inclusive governance is really a key word. Thank you for that. But there are challenges. We all know there are challenges, notably to decide who are the relevant IFBs, as well how they can participate in the agreement. And there is a third level of challenge, which is that they have to prepare. So I have a map behind me to show you the large number of regional fisheries bodies that are currently working on the sustainable management of fisheries in the ABNJ. And FAO works very closely with these bodies at the level of giving them support, not just to them, but also to the states behind these bodies, of course. And FAO will certainly be playing a role of a relevant IFB. These roles can be, of course, very different depending on the character of the organizations. However, for regional discussions, so topics, which are more regionally specific, we think that the BBNJ agreement will rely more on groupings of RFMOs or individual RFMOs, and there lies some challenge because they haven't developed any kind of representation method for playing that role. So that has to be still explored how that can be done. So far, what we know is that there are situations where the member states participating in these bodies take that role of representing the RFMO views in international agreements. So another challenge is their great diversity, right? So these bodies are not at all the same. They have different mandates, they have different scope of action, and also they are very different in their relations to, for example, FAO. Some of the RFMOs are FAO bodies, others are completely independent from FAO. Some have mandates to take decisions, and some are only having advisory roles. So taking this into account, again, back to the concept of inclusive governance, I think it is important to allow also for the advisory bodies to take some sort of representative role in the different bodies and mechanisms of the BBNJ agreement. And as the not undermining clause was mentioned by all the speakers, I will also come back to that. I believe that has to be also interpreted in a positive mindset. And from a very practical point of view, we see it as an opportunity for complementarity. So in a way, the interpretation of compatibility in the agreement will be really key to how we can operationalize this clause. And of course, from the point of view of already existing bodies, it is natural that we would interpret this as new measures being compatible with those already in place. Finally, a last word about preparation, because I really believe it's important to point out that these bodies are open for cooperation and open to work together with the BBNJ agreement, take it into account. There are even regulatory mechanisms that require them to be in compliance with existing international agreements, but they need to do their own needs assessment and their own capacity building. And FAO is planning to take a proactive role in that. So that's my closing word. And we hope to also get the opportunity of expert level engagement with the bodies of the BBNJ agreement.
Thanks, Victoria. Let's wrap up our first round, focusing on the interpretation of the not undermine. The next round, we're going to be a little bit more on a positive note and to look at how to actually put that and promote cooperation and coordination. This has been highlighted particularly in Article 7G as a principle to take an integrated approach to ocean management. And I want to first turn to David. The SAC-SOC has been put forward as a candidate for the pilot study to establish ABMTs under the BBNJ agreement. But I understand you have been in the process for over a decade, and this is the right momentum for you to kind of tap on this movement. In the process, what will be the range of existing bodies that this process will involve? And what would be the possible modalities that you can actually implement the BBNJ provisions for that? David, please.
Okay, thank you very much. And if I could have my first slide up, please. It's David Vousden on the science panel said a little bit about the scientific work we're doing on this, and we've been working on the SAC-SOC for, more than a decade, 14, 15 years. So it certainly wasn't designed with the text of the BBNJ agreement because we didn't know what it was when we started, but it's certainly obviously trying to hit the same buttons and we're trying to do the same things. So a few words about this, and really only a few words because we're going to have a side event tomorrow, which I hope you'll come to, which actually will deal with a lot more detail. It's a floating ecosystem in the Northwest Atlantic, sits in the Gyre in the Northwest Atlantic. around the islands of Bermuda, and Bermuda's been one of the leading governments that have helped with this initiative. It's really important in the lifestyle, I haven't got time to explain why, but in the lifestyle of a number of threatened and endangered species, turtles, all the Atlantic turtles, most of the cetaceans. It's the only place in the world where the European and American anguillid eels spawn, and we have no idea why. And it's also important for a lot of commercial species, such as tuna and dorado and other species which are commercially harvested through ICAT, and swordfish as well. And the marlins, endangered marlins, are also part of that picture. So next, please. Oh, I can move it, can't I? Right. Cool. All right. So this is where it is, and the red line there is the geographical area of collaboration, which the signatories to the Hamilton Declaration, which is more than a decade old, that's 2014. The governments who signed that, and I use the word government advisedly, delineated this area as being the area they wanted to concentrate on. It's a high seas area. The little I in the middle is the EZ of Bermuda, which is not included in this area. Just a brief recap of that Ocean Governance 101, but it's just to remind you that these are the organizations which we're looking at. IMO, which has overarching responsibility for vessels, etc., and dumping, of course, through London Convention. The International Seabed Authority, and there isn't really any activity in this area, except there are 3 exploration licenses on the Mid-Atlantic Ridge, which is just to the east of that circle. Russia, France, and Poland just recently. And then ICAT, which I mentioned, the International Convention for the Conservation of Atlantic Tunas, which covers the whole of the Atlantic. And there's also a regional fisheries organization. If you were paying close attention to Victoria's slide, you would have seen there's also another organization beneath NAFO there in that white area, which is actually called WCAFC, the Western and Central Atlantic Fisheries Commission, which doesn't have management authority. It's an advisory body. So this is a classic lacuna, a gap in the system. And interesting that although this is an area between the US and Americas and Europe, and in the Northeast Atlantic, we have an environmental body called OSPAR, which deals with a much wider perspective. There's neither an environmental organization nor a general fisheries organization in this area. So those are our government signatories, and I say government because 4 of them are actually non-state actors. So the Azores, Bermuda, British Virgin Islands, and the Cayman Islands, but the other 6 countries are sovereign states. And I should perhaps say that a lot of representatives from those states are here, and I should point that I'm saying that I'm speaking entirely on my own views of this, and these issues have still to be discussed with them more thoroughly. But it's interesting, as this is quite a good example of how we've been trying to work forward. We've also got lots of financial support from France and from Sweden. So these are the operative organizations, and we've got good working relations with them. Our team attends ICAT, has been attending ICAT for more than 15 years. We've also done events at IMO. The Secretariat's been collaborating with us and talking about the PSSA issues. The Northwest Atlantic, we have an MOU with them. We've actually got there's a ban on the VMEs, fishing for the BMEs in the Sargasso Sea, which was put forward by our signatory governments, by the US and the EU, and the UK was a member of the EU in those days. And that's a ban, which is a temporary ban, which has been renewed now twice. And we've also got an MOU with the Seabed Authority. So we're trying to make the system work before it was. We started this work before it was designed, so it seems to fit in with that. There's also a lot of other interests within this region. I mean, this is an area which was identified by scientists as a humpback whale, the longest migratory corridor of humpback whales, just recently, and peer-reviewed. This has no legal significance, but it obviously has a lot of significance as the migration is north-south, south-north, and the main traffic vessel traffic patterns are east-west across it. So there's a collision issue, obviously. And then very early on, 2011, we actually had put forward, the government of Bermuda put forward a proposal that that whole Sargasso Sea area, including their EZ, be described as an EBSA, an ecologically and biologically significant area. And that map shows the areas in red, or pinky red, which are also VMEs under the NAFO. So NAFO has designated those areas as VMEs and has closed fishing on those. Now look at them. Those, if you look closely at that map, you see some of those seamounts. There's a corner seamount, the corner seamount. There's a corner rise seamount system actually extends beyond the NAFO region. So that's an interesting compatible areas possibility. And I'm telling you this because this is our thinking, all of my thinking on this. I'd love feedback on other options as well, because we're thinking of how to move this. This is very much work in progress. And then I thought it'd be useful just to pull together all what there is and what value added does the BBNJ agreement offer us. So those are all that's really 101, right? Those are all the various acronyms of the bodies and the measures, and others have talked about that, but also the non-binding ones, the scientific-based ones, the EBSAs, and the IUCN, which has identified the important marine mammal areas. There's also important shark and ray areas, which they would look at. So what does the BBNJ offer us? Why would we bother to bring a proposal to the BBNJ COP when eventually the time comes? First of all, it offers global recognition, and I think Rena made the point earlier this morning. It's not just the 60 states. We want everybody to be party to it, because obviously the wider the circle of ratifications, the more effective these measures will be. And I also flagged the point, the global recognition. If a proposal is put forward which includes recognition of measures which are taken by regional bodies such as NAFO, such as the closing of the seamounts, those measures not at the moment are only binding on the NAFO members. They will become binding on everyone. So that's quite a major step forward in certain issues. It also offers, which these are rather piecemeal management, piecemeal ABMTs which exist within bodies which are concerned about other things. So by having to put forward a proper management plan and a proposal with proposals for monitoring, etc., and just reflect on the fact that I'm taking the view that if you put forward the proposal, you're going to have to pay for it. So the states who make these proposals, so this is where the GF comes in as important to help states who would need support with that, and other sort of funds as well. And then also it offers what I could call innovative site-specific ABMTs, which haven't been used elsewhere. And one, for example, that springs to mind, it's not been discussed this, but just off the top of my head, as it were, is sargassum. There's been a lot of interest in biofuels, and in certain places, harvesting sargassum as a biofuel is a good idea, but not in the core area of, the scientists would tell us, in the core area of the Sargasso Sea. So we could regulate, that's an issue which is not regulated, which would be a site-specific ABMT. And then we can also extend it to unregulated activities. And here we're chatting to different difficult areas, but quite interesting ones, I think. Famous case of submarine cables, which are unregulated, whether they need environmental impact assessments. They push back fairly strongly on that, the private sector. Fishing for non-tuna species. I mean, remember that only less than 10%, is it, of fish species are actually target species. So there are impacts on those other species as well. What those would be, we have to talk about. And then the other issue, which I think is really important, is that by putting a proposal forward, the COP may not decide that they will do it themselves, but they can recommend it to others. So that's an idea of the sort of pressure that they could put on other bodies. So thank you.
Thank you very much, David. I think this is going to be a concrete example of how this provision will interact with the existing bodies. In your discussion, you also mentioned the importance of conducting EIA for the activities that might take place in the area. So move on to Hene. If I may ask, jumping to the EIA sectors, that there are, so state parties are obliged to undertake EIA process, but there are exemptions. And the requirements, if the activity has already been carried out by an equivalent process or being managed in a way that fell under the threshold. Can you give us some interpretation of what would be the exemptions could be implemented?
Thank you, Zhen. And Article 29, paragraph 4 has been pointed to as being a big loophole in the BBNJ agreement. It is the result of the obligation not to undermine, or the agreement not to undermine, the work of IFBs if they have conducted environmental impact assessments or have otherwise ensured that the impacts of activities are assessed. I mean, and that's the negative approach. I mean, a bit more positively, you could say that the wish is not to duplicate the good work that's being done elsewhere. But then still, the question remains, what is the loophole? And I think, first of all, it is very important to point out that the two exceptions under A and B are cumulative. So that means, in particular, with respect to B2, the measures designed to prevent, mitigate, and manage impacts, that there's not a standalone carve-out. It really has to be read in conjunction with paragraph A, and that is often misunderstood. But then coming to the two exemptions under A and B, the first one, equivalent environmental impact assessments. And so what could be the examples here? First of all, deep seabed mining, exploitation in particular, not prospecting and exploration. They may not meet the threshold, but the exploitation is likely to meet the threshold. So too early to call, because we're still developing the regulations for exploitation in respect of deep seabed mining. So there's still an opportunity to review them and make sure that they're equivalent. Another example, a dumping of waste and other matter covered by the London Convention and London Protocol. If you look at the impact assessment process, then both under the Convention and the Protocol, rather hortatory. I don't think that meets the standard of equivalence. Third, also in the context of the London Protocol, the 2013 amendment on ocean fertilization, that one actually comes closer to the mark. Now moving on to B2, measures designed to prevent, mitigate, or manage impacts. What are the examples there? I'd say one example is navigation. So the IMO regulations and standards, including MARPOL, are relevant here and probably would meet the exemption requirements. Then moving to fisheries, very controversial, and I think one of the reasons that the provision was introduced. I'd say that fisheries governed by RFMOs, provided that they apply scientifically established maximum sustainable yields and are based on the ecosystem approach and precautionary approach, and do have effective enforcement measures in place against IUU fishing, would meet the requirements of this exemption. So, yeah, there is a loophole, the risk is there, but then I'd like to point to what can be done under the BBNJ agreement. First of all, I mean, there is still the requirement to determine whether something's equivalent or not. And also, on the basis of the discussion yesterday, actually at the moment, there's nothing, really nothing that is equivalent to the BBNJ agreement, in particular not in terms of the process, in terms of internationalization and transparency. There's nothing that is out there at the moment that meets those requirements. In this respect, it was also discussed yesterday, the BBNJ agreement is very progressive. The second one that I would like to point you to is in Article 29 are the determinations that are required with the party with jurisdiction or control over a planned activity. Those determinations are decisions under the BBNJ agreement, and that raises a lot of new questions. For example, is the call-in mechanism under Article 31 applicable to this or not? Probably not if there has not been screening, but I would say yes, if there has been screening and it is decided not to proceed with an environmental impact assessment. Then, could this be brought under the mandate of the ICC, the Implementation and Compliance Committee? It's certainly good, but you would have to provide for it. And finally, the dispute provisions of the BBNJ agreement would be applicable here. This would clearly relate to an application of the BBNJ agreement. So definitely, yes, that could be part of a dispute settlement procedure. So I would say there seem to be loopholes, but there are pathways for closing the gap. Thank you.
Thanks, Renee. It's a reminder that the EIA provision contained in the BBNJ agreement is way more advanced than what we have for now. So let's hope we can put that into practice. And continue on this reflection on working with other bodies. You have worked a lot with regional Cs and other sector bodies, including the London Convention that Renee just mentioned and IMO. So reflecting on the past work, can you share your perspective how this equivalency and or compatibility has been used or could be applied in the context of BBNJ agreement?
Thank you. Thank you, Zhen, for the questions. And you will have seen that I'm a bit of a mapper, compulsive mapper. So yes, I would like to talk a bit about the regional Cs, because they haven't been very much part of our discussion until now. And I believe that they actually have a space in the context of the IFBs and the implementation of the BBNJ agreement. And I think there's, I'd like to give 5 reasons for that. First, there are many of the regional Cs actually include areas beyond national jurisdiction or discuss it and are thinking about it. And in any case, they most of the time share a boundary with the ocean beyond national jurisdiction. Second, as the discussion on adjacency has shown, and as is repeated constantly by ecologists, sociopolitical boundaries are nonsense to ecosystem functioning. So thinking connection between regional Cs and the BBNJ agreement and continuity and connectivity is quite essential. Third, different parts of the oceans show different characteristics, including geographic, climatic, specific marine ecosystems, culture and politics. It can make sense to think in different parts of the ocean, including within and beyond national jurisdiction, rather than isolating out areas beyond national jurisdiction. Regional Cs, and when I'm talking about regional Cs, I'm not talking about UNEP regional Cs, but really regional sea areas with both structures of governance that have been driven out of the UN and others that have been very much built regionally and are sui generis. They work on developing mechanisms between the bodies focusing on the protection of the marine environment and sectoral IFBs, such as RFMOs. And we've seen, for example, both in the Caribbean recently and in the Northeast Atlantic in the context of the OSPA NIAFC collective agreement. The regional Cs have also been developing mechanisms on monitoring and on quality status assessment that should be built on. And several are also developing experience and guidance on the restoration of degraded ecosystems. So there we can see that, in fact, there's a number of provisions in the BBNJ agreement that can be implemented with some of the support of regional Cs work, existing work, in the spirit of not doubling up, but leveraging the work that's already ongoing. They already hold, a number of them actually have very useful data sets and regional marine research bodies to be leveraged also in the context of the implementation of the BBNJ agreement. So, and on this last point, the need for the scientific monitoring of relevant ecosystem in ABMTs and the capacity point that was raised yesterday that is found in Article 44.1h of the BBNJ agreement points to the relevance, if not the necessity, to include Regional Sea's work to ensure a coherent understanding of the status and pressures, as well as coherent measures in connected parts of the ocean. So, I mean, I think the key point is that mapping IFBs with their full profile, so the mandate, the members, decision-making powers, measures that have been adopted, and existing collaborative agreements between distinct sectoral, so regionally, sectoral, regional and sectoral bodies would be useful, in addition to obviously doing the same work for the global IFBs, and that goes without saying. I'll stop on that. Thanks.
Thanks, Yona. For this previous 3 sections, we mainly focus on COP's capacity or competence. Nicola, if I may turn to you to ask, there will be other bodies established by the BBNJ agreement. Could you share some of the opportunities could potentially be the opportunity for the sectoral bodies, subsidiary bodies, and the BBNJ to work with IFBs?
Absolutely, thank you. And so for this, because we're short on time, I'm just going to focus on one body, and specifically the scientific and technical body. And maybe actually more broadly thinking about how the BBNJ science and technical body might liaise or collaborate with other scientific entities. And also how other scientific entities might sort of provide input throughout the BBNJ process. And again, my focus is on ABMTs, so I'm just limiting my discussion here to thinking about ABMTs. So, you know, for example, going back to this pre-proposal consultation phase that I mentioned earlier, before this ABMT proposal is even submitted, you could see an opportunity for the proponent or proponents of a proposal to actually seek out scientific advice from other IFBs. So many IFBs that we're considering here have their own respective scientific advisory bodies. So you could foresee the possibility where, as part of a state's or party's development of a proposal, they might actually seek out scientific guidance from the scientific body of IFBs, and that might be an opportunity to sort of get that input from other scientific bodies as part of the ABMT process. And similarly, you could see as part of the actual formal consultation process, once the proposal has been submitted, you could imagine that an IFB may draw on its own scientific advisory body to, as it's considering what feedback it may want to provide as part of this consultation process. And I should also note that in addition to IFBs being invited to provide feedback on proposals, scientific entities, organizations could also provide feedback in their own right on a proposal under 21(2)(c). Additionally, in thinking about the BBNJ scientific body's assessment of an ABMT proposal, so this is after ABMT proposal has been submitted, the consultation process has happened, and now it's with the STB to consider and review and advise. If you go to the article that actually establishes the scientific and technical body, there's some vague language there that empowers the STB to draw upon advice from other expertise, from other scientific bodies. So you could foresee that it might take advantage of that option as it is considering and reviewing a specific ABMT proposal. And then maybe just in addition to that specific ABMT establishment process, you can foresee some ongoing opportunities for science-to-science collaboration, science-to-science coordination. So again, looking at that language that establishes the STB, you could foresee potentially regular consultations between that BBNJ STB and other scientific advisory bodies. You would have to presumably think about that when you're developing the modalities for operation for the STB. So all of the delegates who are out there and attending the PrepCom, something to consider. And similarly, you could see where IFBs, when thinking about the invitation for IFBs to report to the BBNJ COP on all of the amazing things they're doing to support BBNJ objectives. Again, that IFB may draw upon its own scientific or technical bodies to help develop that sort of reporting. And then in thinking about the monitoring of area-based management tools, again, we have some vague language that the STB is going to monitor and review. That's quite a lot of work to be done. And again, you could foresee the possibility of potentially collaborating with or reaching out to other scientific entities to support that monitoring and review. And then maybe just some final, thoughts in thinking about these from a perspective, so thinking about operational modalities for different IFBs, and also just in thinking about, if you are an IFB preparing for the future BBNJ's entry into force. So I think it's important to consider sort of timing and scheduling, right? People, I'm sure everyone in this room is all too familiar of the pretty hectic schedule that all of that map that Victoria showed of all of the different bodies. They all have annual meetings of their main body, but then they probably have their own subsidiary bodies. So it's thinking about that scheduling and ensuring that you are keeping that in mind in your modalities and procedures for reviewing, for providing input on ABMTs is important to consider to ensure that you really are enabling IFBs to provide thoughtful feedback. But similarly, I would argue that IFBs, or perhaps more specifically states who are members of IFBs, now is a good time to start thinking about how you ensure that that IFB is BBNJ ready. So for example, you might consider adding an agenda item in that IFB or starting to make moves to, in the near future, add an agenda item so that that IFB could consider any sort of BBNJ content that comes its way once the BBNJ has actually entered into force and is operational. And I'll leave it there. Thanks.
Thank you, Nicola. I particularly like you highlight that the IFBs actually have a little bit more advantage because they're already in business. They can think ahead how to interact with BBNJ. So Victoria, again, I'm giving you the last words for this round because I think this mainly relates to FAO has been in operation for decades and have extensive working experience with different bodies. You also highlighted the scope that FAO has been established with IFBs. So in this working processes, can you share whether you have drawn some lessons, good practices that you can recommend for the interactions between BBNJ and IFBs?
Thank you very much. You will see on the screen another slide, which I consider very important, because in practice, there is a wide recognition that sustainable use and management of living resources has to go hand in hand with strengthened biodiversity conservation. And I'm bringing you a number of examples, a number of types of examples, how this is done in practice. I will start by saying that this all starts at the level of objectives, and the BBNJ agreement has done something very important with confirming a number of key objectives for biodiversity conservation. And in terms of examples, how these objectives are taken into account in the work of the different bodies, I would highlight the ecosystem approach to fisheries management, because, for example, this year there have been quite a number of resolutions at the different regional fisheries bodies on promoting electronic monitoring. This is just one example, but ecosystem approach to fisheries management is recognized and being promoted more and more, and a lot of effort is put into making it operational. Another level of cooperation is between different bodies is through MOUs, Memorandum of Understandings, or other types of arrangements, and two of those have been mentioned today already. The Sargasso Sea Commission cooperates with with ICAT and NAFO, for example, but we also heard about the OSPAR and NEAF cooperation, which is a very special way of cooperating on information sharing, on deciding how to manage certain designated areas within the Northeast Atlantic region. So these are two types, and I have three more to mention. because the RFMOs and the different bodies active in the governance of the ABNJ, they also participate in voluntary partnerships. And two examples of that is the Common Oceans Program. And in fact, David here is also managing the Sargassosi project, which is one of the projects of the Common Oceans Program. But within that program, we have two fisheries-focused projects, which include all the RFMOs. So one of them covers all the tuna RFMOs, and the other one covers all the deep sea RFMOs. Of course, it's a more inclusive partnership. We also have other partners, other stakeholders on board. I would just like to bring you the example what they are doing, because, for example, the tuna, within the framework of the tuna project, from all all areas covered by the tuna RFMOs, there are skippers, so fisher folks, who get together in the framework of workshops all across the world. There have been more than 4,000 of them trained, together with marine scientists, to understand better how to deal with bycatch, to learn release techniques, and to keep their knowledge updated on it. There is also, in the deep sea fisheries work, probably many of you know, the vulnerable marine ecosystem work that has been ongoing for decades now. And related to that, there is also data collection cooperation, which I would like to mention. And just recently, we had an observer training in Mauritius to train observers, again with the help of scientists, to make sure that they do their work in the right way, to make sure compliance with the rules on the various fisheries vessels. So this is the voluntary partnership. I'm mentioning that because it's important to know that these organizations also need to build trust because of the different mandates they have and the different memberships they have. The trust issue is key, and to share information and experience among themselves is taking that its time. So I have two more very brief examples, but I would like to reflect on interinstitutional cooperation at a higher level as well, because there is, for example, a joint working group on IUU matters. So you all know what IUU, so I will not spell that out, but FAO is working together with IMO and ILO in the framework of this joint working group. And that also covers, in addition to IUU, marine environmental protection. And they together try to develop tools to basically work and address the compliance with the international regulations better. What is interesting about this joint working group is that it started with a specific problem, addressing a reflagging problem of fishing vessels. And now we can also observe how it triggered some changes in the way how national administrations cooperate together. And the very last word on data sharing and cooperation. I have some examples, and I'm happy to answer any questions on that, but I would like to mention a number of databases. The FIRMS database, which is a fisheries resources monitoring system. It's, again, a voluntary partnership of intergovernmental bodies to share fisheries data. And related to the Port State Measures Agreement, there is the GIES, which is the Global Information Exchange System, which is promoting compliance with the PSMA provisions. Thank you.
Thank you very much, Victoria. I hope our group interventions will also help to clarify some of the questions that you might all have. We have about 15 minutes. I would like to invite a round of questions. We gather 4 to 5 and see how far we get with that. When you ask a question, please identify yourself and please keep your questions or comments brief. Any written hands from now, or please also ask our colleague to show the questions online if there are any.
I'll start speaking into this. That'll help. Hi,
Yes,
I'm
please.
Mitchell Lennon from the University of Aberdeen. Thanks to the panelists. I thought all of those interventions were really interesting. My question's for Victoria. I'd like to hear your thoughts on whether you think there's a role to play for the regional fisheries bodies secretariats network in kind of promoting cooperation and coordination between the BBNJ process. Thanks.
Thank you. That's the first question. Over the back.
Okay, thank you. My name is Zaki from Indonesia. My question is for Victoria. Thanks for Rini to identify some provisions with regard to the purpose to fill the gaps. And I think it is important for FAO in particular or other IFBs to have early communication and coordination with regard to the provisions of BBNJ to have more operational on the ground. For example, if we refer to Article 10 with regard to the application of MGR, I observed that it is necessary for FAO to have communication or to how to interpret or how to make clear understanding on the application of fishing and fishing related activities. So it says here, Article 10, paragraph 2, B, fish or other living marine resources known to have been taken in fishing and fishing related activities for areas national jurisdiction, except where such fish or other living marine resources are regulated as utilization under this part. So I think it is necessary to interpret or to know in more detail what to be known. So if this agreement enters into force, so it doesn't have any multi-interpretation in that sense. So my suggestion is, again, I want to seek your opinion, how to make this article to be more operational. Thank you.
Thank you very much. Do we have another question in the audience? Yes, please, at the back.
Thank you very much. I'm Huang Hao from the China Ministry of Natural Resources. I have one question is about if the BBNJ will put forward the new types of area-based management tools. Since the FBS has designated the MES or the APIS, so I wonder if the BBNJ will put forward the new tools. Thank you.
You mean different names of the marine protected areas? Whether we will use different names to propose the ABMTs or continue to use MPAs or and other regimes. Okay, we have another question over there. Thank you.
Hello, Daniel Casheries, cross-cutting coordinator of High Seas Alliance. I have a question that relates a little bit to the PrepCom elements, terms of reference modalities, and how it relates to other relevant bodies frameworks. In terms of the timelines for consultation, I used to work for the CITES Secretariat. CITES has a provision that for listings of marine species, the equivalent of IFBs, so bodies with a management function for marine species, are being consulted. And one of the challenges from that process is that in the timeline that is available for the consultation, not necessarily all of the relevant bodies can get a mandate from their governing body to answer. And so FAO, for example, through an MOU with the Secretariat, has put in place a process to be able to convene an ad hoc expert panel to provide that type of advice. But some of the regional fisheries bodies, for example, don't have a process like this. And I'd be curious for reflections on, are there any things that need to be reflected in the modalities of some of the BBNJ subsidiary bodies, but also is there work that needs to be done within some of the bodies that may need to be consulted in order to sort of enable timely advice and consultation? Cheers.
Thank you very much. We have a question over there.
Yes, Bastiaan Klerk from the University of Tromsø in Norway. Thank you to all the speakers for your interesting presentations. I like the positive twist that a lot of speakers put on the not undermining clause, and forgive me for my question maybe being a little bit more skeptical. I was just thinking that I'm afraid that it may be easier for states and IFBs to leverage the not undermining clause to protect their own mandates, while it may be more difficult to sort of legally enforce this, these objectives or obligations of coordination and cooperation. And at Nicola in her presentation, she highlighted a lot of ways in which IFBs can cooperate in the BBNJ framework. But as René in his presentation pointed out about CAMLAR, and we've seen in the Northeast Atlantic with OSPAR having a lot of difficulties in getting, for example, the ISA and the IMO to cooperate with them in coordinating their measures. So my question is, if some IFBs and states do not have a lot of appetite for the BBNJ agreement, are there some legal tools or safeguards in the BBNJ agreement that can sort of push them or force them to engage more actively? Thank you.
Thank you. Let's take the last question at the back, please.
Yeah, Amber Schultz from Leibniz Institute DSMZ, and I'm a marine genetic resources or an access and benefit sharing or a digital sequence information sort of specialist or expert. And I was really interested in this panel. And then at the end of it, I was sort of surprised that one of the 4 pillars sort of didn't come up amongst the panelists' discussion. And in particular, the issue of digital sequence information is a really cross-cutting issue and requires cooperation with other international instruments, with other IFBs, in particular the Convention on Biological Diversity, as well as the Food and Agricultural Organization's Plant Treaty Agreement and the WHO's Pathogen Access and Benefit Sharing Arrangements, in which 4 UN bodies are making rules in parallel on how to govern digital sequence information, and all of that's held in one single global database. And so these are really complex, really technical issues. And I guess it's unfortunately not a question, but more of a comment to sort of say one of those pillars that wasn't discussed today is another one where I see as a stakeholder a huge need for cooperation across multiple IFBs.
Today, thank you for that. As I gather, I think Victoria's a bit busy. You got 2 of the fishery-related questions. David, you can take whether we have kind of what name do you want to name your SAC-SOC protected area? Then we have what if the IFBs are not taking actions? So perhaps I'll turn to Victoria first, and anyone who wants to follow up, we can take that. Victoria, please.
Yeah, so thanks. It's an interesting question. I think part of that name question, if I've understood it correctly, is that we are going to, I think that the system respects the existing names which other organizations bestow on them, right? In terms of, this is a PSSA or this is a, a fisheries closure or whatever. So, but in the overarching, an overarching area which would be designated by the COP, I mean, we have to play that by ear. So yes, it'll have an overarching name, I would imagine, if that was the question. And the COP may decide that it wants to invent its own terminology on the advice of the scientific and technical body. I think that'll probably be fairly low down the list, but it's an interesting issue because it is a question of who puts their mark on a particular decision. So it's interesting. We'll see how we go. And this is not a decision, a question that I, as the executive secretary, are going to answer. It's going to be something that the parties, our signatories and the parties to the convention will have to agree.
Yes, thank you very much for the question. So the Regional Secretariat Network of the RFMOs is a facilitating body. Maybe you have heard about it, but basically at this body, the secretariats participate. And that gives it a very particular profile because it does not allow for using this body as a representative body of a grouping of RFMOs. It is usable or well used for information sharing, for exchanging experiences, and it has offered a platform for dialogue for the different regional fisheries bodies. So it is a relevant forum, but its role in terms of representation is a bit more difficult. And on the other question related to the marine genetic resources and the exemptions in the provisions, I would say that it's not the only provision in the agreement which will require more interpretation. So we are looking at it very carefully, of course, at FAO level or at the different frameworks and bodies, but it will be mainly through the work of the BBNJ bodies that this interpretation work will happen. FAO is ready to assist any of those processes, but it has to be led by the bodies of the BBNJ agreement.
Thank you. Nicola, you take on the question of if IFB are not acting, whether there are any legal remedies for that.
Absolutely. And if I may just quickly first also reflect on the what's in a name question, one of my favorites. So to say, I think there was a bit of a debate as to, and I love to use this because it's only in a room of BBNJ friends that I can say something like, well, what sorts of ABMT tools besides MPAs might BBNJ adopt? Because that's just a mouthful of acronyms. But thinking that ABMTs is the broader category of tools. Marine protected area is one type of tool. But the treaty text is very clear that it actually is with regard to the broad suite of tools, of all area-based management tools. And while I think there was a lot of soul searching within the negotiations as to exactly what sort of non-MPA ABMT would the BBNJ COP adopt, I think it was included in there ultimately to give flexibility and to future-proof the agreement for precisely your point. As new tools emerge, that BBNJ may be the appropriate body to sort of adopt them. It gives it that flexibility to do that. So just another thought. And then on the question about what levers might the BBNJ have to incentivize cooperation amongst IFBs, I'll reflect on. I was at a North Pacific Fisheries Commission meeting last year where somebody gave a presentation on what BBNJ means for the North Pacific Fisheries Commission. And the presenter said, to paraphrase, something along the lines of, if the NPFC does not act, BBNJ is coming for you. Now, I don't know if I would describe it that way, but I do think it certainly woke up a couple of delegates. A lot of the language is sort of around, especially in the ABMT chapter at least, it focuses a lot on competence. And I think if an IFB fails to demonstrate its competence, then potentially that opens up more room for the BBNJ COP to act. So I think they potentially have a natural incentive to demonstrate their own competence in an issue by acting and cooperating.
Thank you. Yuna, if you want to comment on the consultation process quickly.
Yes, thank you. I agree, I would echo what Nicola just said, though I've also had the opposite face the opposite situation in several bodies where the position is that until the BBNJ agreement comes into force, there's no reason to worry too much about it. So some are being proactive and indeed have taken that stance, but others are going the other way around. Now to the questions, what if they're not taking action? I think what the question then is, who is not taking action? And that will go down to political wills and particular states. And so the question is, who is at the seat? Who's around the table in the BBNJ agreement and who's around the table in that RFMOs? And there's also, and then if it's an IFB, which is the regulatory authority, I think there's no real point bypassing them because without them, it is impossible to ensure compliance anyhow. So then it's about what I'm hoping very much is that the BBNJ agreement will be the glue and the convener. And so we have a number of existing processes. There are gaps, but there also are processes. And if they could work together, that would finally, that could possibly, or well, that would certainly progress much and much more than it has been until now. So I'm just all for the glue and convener. I don't know if you agree with me.
Thank you very much. With that, I'm running out of time, to be honest. It's not that I didn't want to give the panelists more time to reflect on your questions. I can assure you that they will be around. If their questions are unanswered or if you have more, please approach them. For now, please join me to thank our panelists for this interesting discussion. Thank you.